So I have an important update in the current lawsuits against the ATF and their pistol brace rule, including the nationwide injunction. So we need to talk about what is happening with pistol braces. So like I mentioned in the intro, I have an important update in the ATF pistol brace cases. The ATF is currently pushing for the Fifth Circuit to overrule multiple lower court decisions which block the enforcement of that rule. The ATF now argues that all the lower courts either got the analysis completely wrong or that the lower courts issued injunctions that granted relief beyond what those courts could actually do and was essentially beyond those lower court authorities. The ATF has now called for oral arguments in all these consolidated cases, and they seek a reversal of all the limited preliminary injunctions and also the nationwide injunction that is currently protecting everyone. But the Supreme Court's looming decision in the Cargill ATF bump stock case is now impacting the pistol brace challenges and is likely going to dictate what happens from here. Now, you may recall that the ATF recently decided to roll the dice and appeal all the pistol brace cases up to the Fifth Circuit Court of Appeals. Those appeals include the Mock v. Garland FBC case, the Brito versus Garland, a nationwide injunction that was issued against the brace rule, the SEF case, the NAGR case, the GOA case, and all those lawsuits are now also in the Fifth Circuit. Although the ATF already lost once in the Fifth Circuit in the Mock v. Garland case, the ATF decided that the lesser of evils to them was to appeal up to the Fifth Circuit to the en banc panel and see what would happen. The circuit has consolidated review in multiple brace cases, and the ATF is now arguing essentially that all these cases should be ruled in their favor. The ATF now argues that despite what the Fifth Circuit said originally in the Mock case, the lower courts were wrong to follow that ruling. And essentially, they incorrectly relied on what the Fifth Circuit said in Mock. They also doubled down once again that the relief granted in the lower courts, including the Brito nationwide injunction, is too broad and therefore also must be struck down. Now, if you're not aware, recently in the Brito versus ATF case, Judge Matthew Kaczmarek issued a preliminary injunction which blocked the pistol brace rule in its entirety while the case proceeds forward on an actual merits review. This decision by the judge there, Judge Kaczmarek, essentially springboarded off of a recent decision by a different judge, Judge Reed O'Connor, in the Mock v. Garland pistol brace case. However, in the Brito case, the judge there kind of went the extra mile and granted a request for an injunction against the entire pistol brace rule, and that was a nationwide injunction. So that decision by Judge Kaczmarek essentially is an order which blocks the enforcement of the brace rule nationwide until the Brito case is fully decided on the merits. Now, originally in the other case, Mock v. Garland, the Fifth Circuit reviewed a judgment by Judge O'Connor, and essentially he granted an injunction, but it was a little bit more limited and only protected FBC, its members, and then also some of the companies and their customers. Mock was kind of that first major pistol brace win that then kind of set the stage for the Brito nationwide preliminary injunction that was then issued by Judge Kaczmarek. The ATF now argues in their appeal to the Fifth Circuit that all of those lower court decisions and all those injunctions, like the Brito nationwide injunction, and then even the limited FBC and membership, injunction that was issued, were overbroad, that there was no likelihood of success on the merits, that there is no injury, and none of these other, factors for an injunction, and therefore these reliefs that were granted by the lower courts were overbroad and must be reversed. In their recent brief, the ATF argues that 3 of the 4 pistol brace decisions correctly limited relief to the named plaintiffs, but that they should have not extended it to named organizations and memberships. The ATF argues that the Fifth Circuit should reverse the Mock, Brito, Texas gun rights case, and then also the GOA case because of the scope of relief that was granted to those plaintiffs. One of the ATF's main positions is that at the very least, the Fifth Circuit should vacate the nationwide injunction, that they should vacate that nationwide stay of the rule in the Brito case, and essentially maybe even leave it limited to just individual named plaintiffs in all those lawsuits. The ATF argues that the Brito District Court erred in relying on Mock. Plaintiffs did not include any logical outgrowth claim in their complaint or their motion for a preliminary injunction. To the contrary, they expressly waived any such claim even after this court's decision in Mock. The district court's award of relief on their grounds thus violates the fundamental principles that courts normally decide only questions presented by the parties. So not only does the ATF argue that the Brito decision there was incorrect, but they also said that the use of Mock in that ruling to support the conclusion for the nationwide injunction was also incorrect, and that universal stay of the brace rule, the nationwide injunction, should be removed. The ATF then also goes on to argue that even if the likelihood of success on the merits claim was present, they believe that none of the parties can show that the pistol brace rule actually creates an irreparable harm on the plaintiffs or the public at large. The ATF essentially argues first that having to pay an NFA tax and go through the process is not actually an injury, that it's not a injury that meets the injunction standards, and therefore, again, that the lower court should not have granted that relief. They also tried to wiggle out of claiming that there was an actual injury to the plaintiffs and other individuals by saying, well, we waived the NFA tax stamp requirement. It was waived for a period of time. And again, that tax injury is not sufficient. And even if it was, we waived it for certain individuals. And then they go on to say that the allegation that there was an injury to the Second Amendment and the right to keep and bear arms, that essentially a constitutional injury is not enough for irreparable harm. The ATF argues that these firearms configurations are in fact short-barreled rifles, and because they believe they are short-barreled rifles, they then claim that they are dangerous and unusual weapons that do not fall inside the protection of the Second Amendment. And as dangerous and unusual weapons, they are not arms, and therefore, since they're not arms, they do not fall within the text of the Second Amendment. They also go on to say that even if these items were in common use and that ownership of braces was widespread, it doesn't change the analysis at all. The ATF simply claims that would then mean that there was just simply common use of illegal firearms and common use of dangerous and unusual weapons. But that's kind of an oxymoron because the whole dangerous and unusual analysis is defeated by a showing of common use. So also in their brief, the ATF once again tries to make the analysis dangerous or unusual instead of actually what the test is, which is a conjunctive test, which is dangerous and unusual. The ATF argues that Congress already identified these weapons as inherently dangerous, through the NFA and through the statute, and they also say that some states have done the same. So instead of doing the whole historical analysis of dangerous and unusual, they simply say, well, Congress in some ways and in some states restrict SBRs. We have now defined braced pistols as actually SBRs, and therefore they are dangerous and unusual weapons, not protected by the Second Amendment, and we can do whatever we want. You can see that how this is kind of circular, and how the ATF is saying in some ways they are the judge, jury, and executioner who gets to decide when people can exercise their Second Amendment rights. Now, the most concerning thing about what the ATF is currently doing on this appeal is again that they are trying to remove the nationwide injunction that was issued in Brito. The ATF is also asking for the Fifth Circuit to remove the protections that were granted to all the 2A organizations and their memberships. Now, right now, we've seen, very little major movement in this case. Right now, the Fifth Circuit is waiting to hold oral arguments in this case, actually review the brace issue. Some briefs have been submitted. And also, some of these cases are being reviewed still at the lower court level on motions for summary judgment. But again, nothing huge has developed in these cases. And that's likely now because what is going on with the Supreme Court in their looming decision in the Cargill ATF bump stock case. We also have a looming decision out of the Supreme Court, which is going to be in the Rahimi case, and all of these decisions and rulings will happen within the next month. So the Cargill case, which deals directly with ATF overreach, the regulation of bump stocks, will directly impact what is happening with pistol braces, unfinished frames and receivers. The Vanderstock case, which was also granted review recently, is going to impact that case. And then also some of the private party transaction cases that are currently developing, and then just all 2A cases at large. And then we also have a lot of Chevron deference cases, which have also been heard and are set to be decided here within the next month. And that is all to say why we are seeing a huge stall in the pistol brace cases is because of these looming decisions. It's my opinion now that, nothing is going to develop, especially in these ATF cases, until after the Cargill decision is issued by the Supreme Court, until after the Chevron deference cases, until after the Rahimi case, and then we will see, how the chips fall, what the Supreme Court says, what the language is, and then you will see all these cases move forward after, because the judges here, especially in the Fifth Circuit and some of these other circuit courts, don't want to issue an opinion and then, a month later, the Supreme Court changed the precedent and then them have to kind of do everything all over again. Instead, it's better for them to hold the decision now, to not hear the case, not rule on it, see what happens with the Supreme Court, and then, get additional briefing on what the Supreme Court says, and then actually decide on their own. So that's kind of what's happening here. If anything else changes, if anything else develops, I will let you guys know. Also, if you guys like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, but never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.